May it please the Court, Jay Kubicek for the State. When we evaluate a claim under the Sixth Amendment right to a speedy trial, we always look at it in the view of what that right is supposed to protect. It's supposed to protect against oppressive pretrial incarceration, the anxiety of awaiting trial, and whether a defendant's case may be prejudiced. Now, the first two, the defendant was not incarcerated during the 8-year period, so those aren't really the concern here.
But doesn't Barker really start from the point of view that it's based on a speedy trial, so it focuses on the length of the delay, not on prejudice is not the upfront issue. The length of the delay is the number one Barker issue, is it not?
That's correct. And the very final bit that the defendant has to carry in order to prevail is prejudice. If the defendant is not prejudiced, then he doesn't prevail. It was pointed out by the United States Supreme Court that a delay is a two-edged sword. It benefits the state, or it might benefit the defense. In fact, more often than not, it benefits the defendant and is often a reliable defense strategy. Over time, the state's witnesses lose their memory. The state's the one with the burden of proof.
Well, that may be true, but insofar as there is a presumption of prejudice, who has the burden of rebutting that presumption in a case such as this, where there's been an 8-year delay between the information and the capias and the ultimate apprehension of the defendant?
In that case, the state would have the burden of rebutting it.
And did the state bear its burden in this case?
That is correct. The state did. Because not only was the defendant not prejudiced, the state was.
How was the defendant not prejudiced?
The state's evidence, the entire case, rests on the testimony of the victims and various hearsay statements that might be given to people who talked to the victims afterwards. The victims had serious memory problems afterwards. 8 years passed. The younger of the two, who was 4 at the time of the incident, doesn't really remember much of anything. The investigating detective doesn't have an independent recollection. And the place where the children were interviewed, Sutton Place, lost all their records.
Doesn't it seem odd for the state's position to be, our case is going to be so horrible, so weak, that the defendant is not prejudiced by the 8-year delay? Doesn't it seem like an odd position to take?
No, Your Honor, because it resulted in a windfall to him. It meant that he was in a better position 8 years later, facing less evidence, facing more reasonable doubt that he can bring out to a jury. And the state, having the burden of proving everything beyond every reasonable doubt, and having that doubt out there that the memories of the victims have been compromised by this delay, that makes it incredibly difficult for the state.
Well,
and
let's assume that the state carried its burden to rebut the presumption of prejudice. You've got 3 other factors that appear to weigh heavily in the defendant's favor.
To be clear, the analysis is that no one factor controls for the defense prevailing.
Yes, I understand that.
Yes. However, if they don't prevail on prejudice, then they still don't prevail. However, I will certainly...
Even if the other 3 factors...
Correct, because we don't immunize a defendant potentially for committing heinous crimes, as in this case, molesting 2 little girls, simply because the state dropped the ball.
Is that consistent with Doggett, what you just said?
That is consistent with the rule of law in Doggett. I understand that perhaps the spirit of Doggett may be a bit different. I'd only point out that Doggett is a 5-4 decision, and certainly the federal circuit courts that have since applied it, in many cases, and delay far more than 8 years, have not taken the tack that we are going to punish society because the state wasn't diligent enough.
Well, that sounds exactly like one of the dissents in Doggett, but that was not the majority's decision in Doggett, and that's obviously what we're left with to decide this case. And in Doggett, the majority said that no harm, actual harm, was necessary to establish the prejudice prong because of the excessive delay.
That is not technically correct. What Doggett said was that no actual showing of harm was necessary from the defense, that they would presume harm, and has been pointed out, it can be rebutted, and it wouldn't be a rebuttable presumption if that's an impossible task. Dogged merely stands for the rule that if the first three factors weigh heavily against the state, then we're not going to make the defendant get up and show specifically exactly in what ways he was prejudiced by the delay. We'll allow him to rest, have no burden of proof on the fourth prong, and we'll make the state prove it. Because you know what? They're the ones who dropped the ball. They should show why he's not prejudiced. That is what dogged stands for. Not that there can't be any harm, but we're going to presume that there was harm without a specific showing from the defendant. And if the state can come up later and show, no, there wasn't harm, he's in a better position after the delay, then they don't prevail. And that is consistent with dogged.
And tell us again how the state rebutted the presumption of prejudice.
It was actually both the defense and the state, and that's kind of the irony here. The defense first motion to dismiss recounts in great detail the weaknesses in the state's case that were present 8 years later. Specifically, one of the victims, M.M., has practically no recollection. The other victim is also not quite as much, certainly, but it certainly didn't help her. The investigating officer has no independent recollection of this case, and all records relating to it from the facility where the children are interviewed, they've all been lost or destroyed. The state is left out on a bit of a limb, and certainly I can imagine that between the prosecutor and law enforcement, the state wasn't very happy that law enforcement didn't pursue the defendant, because that left the prosecutor out to dry with less evidence to meet its heavy burden to show to a jury there's no reasonable doubt that this defendant molested 2 girls. And that's a serious burden. It's one that in a case where you've got 2 eyewitnesses and that's your evidence, memories are essential. The defendant received a windfall. Now, as has been pointed out, there are 3 other factors. Of course, the length of the delay is over a year. That does nothing more than trigger the rest of the analysis. And, of course, it does, because it's 8 years. The second prong, because of the delay, the defense says there's no evidence of evasion. And certainly the state doesn't take issue that there was negligence on its own part. But we have to take all of it into account when we decide how to weigh this factor. Now, I'd like to read out the following facts so that we can connect the dots. The incident occurs in January. The defendant is immediately confronted with what he's done by a very angry father of the victims. The defendant then takes off in his RV, leaves Florida. The incident's reported. That's in January. In March, a KPS is issued. In June, the victim's father gets a phone call from the attorney of the defendant. He wants to give him a car. Okay. He wants him to fly to Las Vegas to meet with the defendant to get this car. Now, why the defendant is something curious. As it turns out, because of logistical reasons, the victim's father ends up having to fly out to California to meet with the defendant. Now, what's important about this is that they do have a conversation, and they do at least admittedly at one point mention the incident, saying that the emotion of the moment has passed. Now, in other cases, such as U.S. v. Sparrow, where law enforcement contact a defendant's brother, tell the brother that we're looking for him, there's still no evidence from that the defendant specifically knew the police were out for him. Furthermore, simply engaging in behavior that could be construed as evasive is sufficient for a court to impute knowledge of a specific charge onto a defendant. And I think when we connect the dots, that just 6 months afterwards, the victim's father, who had a prior friendship with this defendant, goes out to California at the defendant and his attorney's request, gets something of value, and then we know 8 years later the defendant reflects back on it. We know in one of the jail calls the defendant says, well, you know, I've kept in touch with him. I gave him a car. And then he goes on to state that he's not going to testify against me. That allows us to connect the dots to show that there's a pattern of evasion trying to avoid the consequences of what the parents accused him of doing.
How do we reconcile the inferences that you're asking us to make with the objective facts that we have? We know that after the capias was issued, he bought, I believe this is correct, he bought property in Florida, he obtained a Florida driver's license, registered to vote in Florida, got parking or speeding citations, some sort of driving citations in Florida. How do we reconcile the objective facts that we have with the inferences that you're asking us to make?
If you're referring to the stipulation, certainly the state is bound by that. However, the stipulation did not go so far as to say the defendant was physically present in his house, the defendant was keeping his belongings here, the defendant was living here. He had a house, yes, and jail calls reveal that he had a guy named Randy living there, and he was keeping the houses in Florida while he maintained his true residence in California.
Where the house, was the property in his name?
The property was in his name.
So he had real estate titled in his name here. He had a driver's license, Florida driver's license. He was registered to vote in Florida. You know, had traffic infractions, tickets or whatnot. If our review of these facts is de novo, are you asking us to place greater weight on the fact that he left Florida for California immediately after these events allegedly occurred in January 2000 against all this other evidence that indicates that he, you know, continued to have many contacts with Florida? Is that what you're asking us to do?
What I'm asking the court to do, if it would be de novo review, and certainly we don't concede that point because the trial court's order, as all court orders are, is presumed correct. But
there were no findings?
That's correct.
No historical findings for us to give deference to?
No specific findings, correct. What this court, the state's position is that this court should do is not ignore the obvious undercurrent of what was happening in this case. Yes, he did have property in Florida, but the intent was to deceive. The intent was to evade taxes. Yes.
But, yeah, evade taxes, but evidently not evade prosecution for lewd and lascivious molestation.
For 8 years he did.
Well, we'd have to assume that he knew that there was a capias out. I mean, we would have to make that assumption, which is hotly contested, that he actually knew charges had been filed.
Given all the individual instances involving the father, involving his statement that the father's not going to testify against me, involving him leaving Florida immediately after being accused, those are dots that this court can connect.
Did the father ever testify that he told the appellant that the capias had been issued?
He did not. And I would point out that the father in this case, indeed any father, who would maintain a friendship after someone molests their children has some serious credibility problems. The trial court certainly was not required to believe every piece of his deposition testimony. Any trier of fact can believe or disbelieve any or all of the evidence. And we do need to look very carefully at his deposition testimony, as we do with everything. One of the appellate court cases, Wana Sige, I think it's pronounced, it begins by stating, or quoting from Paul Harvey, that, you know, we have to look for the rest of the story. We can't ignore that. Certainly not when we're thinking about giving the greatest criminal sanction in our system, which is immunizing a defendant from their crimes. It's the ultimate punishment that reaches beyond the state and into society, based on the defense not having any prejudice that would have been rebutted, even if the state was required to, the state asks that this court affirm. Thank you.
Thank you, counsel.
The father, we have all this speculation, hallucinatory law or of evidence. Why didn't someone subpoena the father, and we would now know when you make a de novo review of this muddled record that is muddled further by this confusing argument, that you could make a finding, but you can't make a finding from this record. The Sixth Amendment was not passed to protect the state. It was other than to apprehend offenders of the law. It was created to protect the accused. Mr. Justice Souter said this about the government's burden. Where the government delays a prosecution for half a decade or longer, the burden is on the government to persuasively rebut a presumption of negligence. This burden arises because extreme delay may create prejudice of which the defendant may be unaware. Accordingly, the likelihood of evidentiary prejudice, though difficult to prove, increases in tandem with the length of delay. In Mr. Doggett's instance, there were 17 tapes of a wire intercept. They were lost. A couple of witnesses had died. Here you have speculative prejudice that's articulated in the record, the loss of some evidentiary items and what have you. But the bottom line of it is difficult without the proper application of these rules to make a de novo finding on a record that has no presumption of correctness to the extent that the state is asking you to make it. You can't do it. And respectfully, this court in a panel decision, a per curiam reversal, a reversal of a dismissal of a case, and Judge Norwick was on the panel in a case of State v. Polk, 993 Southern 2nd 581, says this about the length of delay. The length of delay, this is at page 3 of that opinion, the length of delay is to some extent a triggering mechanism in that it may create a presumption of prejudice. In that event, the court could find a violation of the constitutional right to a speedy trial on the basis of the delay alone without consideration of the remaining factors, and cites to rules here. Respectfully, there is a presumption of prejudice in this case. It's not been overcome by the state. It can't be overcome by the state. They're saying, oh, these two individuals must have talked about this. Well, usually when I'm trying to prove something in a courtroom, I subpoena a witness, I put them under oath, and they testify to that, so that I'm not put in a position here now 9.5 years later, grappling with what were the facts. I've never asked a court to do this before, but I ask you to per curiam reverse this conviction. Thank you.
Thank you both.